With no further ado, I now give the floor to Professor Lee. Can you turn your camera on? Hello, hello, in Seoul. I give you the floor, Professor.
Okay, thank you very much. Thank you very much. Good evening, everyone. It's very hard to speak in this way, but first of all, let me express my special thanks to the organizer to invite me to be part of this program. In particular, my special thanks should go to the Ministry of Foreign Affairs and the Korean Society International. Although two previous speakers touched upon the very important part of the very concept of the duty to cooperate under the convention, I rather focus on the different angle, largely focus on what we discussed from the perspective of the semi-enclosed or enclosed sea under the convention. Before I'm going to talk about my presentation, two presentation in our session just reminds me that whether these kinds of the dialogue, they go with the state practice in this region, in Asia or the part of the world. For example, the recent cases very emphasize the state parties do not hamper or jeopardize the situation. However, and that emphasizes they go to the state parties when they exercise their jurisdiction. However, in comparison with this kinds of the inaction way, when you approach ask the state parties to cooperate with the neighboring state or other state parties, I don't know whether this kinds of dialogue convey with the exact meaning what the drafters of convention design and at the time. So there is a strict distinction I can notice between the state practice and the terminology of the very nature of the convention in these circumstances. And also these two presentations together with mine just remind us that the role and the function of the international judicial bodies is very much important, including international tribunals law of the sea. When they interpret and apply the various articles, including the relevant articles to cooperate in actual cases, they may fill the gap when we have the faced with the actual cases or actual practice. So in a sense that also there is some limitation, we can notice that since the convention we use is done is 1982. It's almost 40 years ago. So that at the time the drafters never imagined what kinds of things happen in these years. So that the couple of the ideas came from the academic largely in terms of the amendment or the new codification of the convention. And that in a sense that to enhance the clarity of some of the articles we are dealing with the convention is very much needed. And that two issues I want to share before my presentation today. The outline of the presentation is largely the three parts. The first is introduction, and they go to the elements of duty to cooperate together with a couple of international cases, and then the brief concluding remarks. Although two speakers in our session mentioned about very important cases dealing with the duty to cooperate, I'm not going to repeat. However, to facilitate my presentation, if there is some needed, I have to mention that. So, in that regard, even if the duty to cooperate and the cases referred to previous presentation, they make again. So I hope that you understand the very purpose of my presentation. When we discuss the matter of the enclosed or semi-enclosed sea in this region, in particular Northeast Asia, and if we go a bit south, the Southeast Asia, we cannot go without the South China issues. And still, what happened there and what the award 2016 provided us, there's a serious gap. And that field gap is, I think that is the difficulties we face with when we apply to interpret that the conventions, the article to specific case. We understand the Article 122 of the convention say very definition of the semi-enclosed sea, which mentioned that it is surrounded by the two or more states and connect to another sea or ocean by a narrow outlet, or consists entirely or primarily of the territorial sea, so easy, or the two or more coastal states. So derived from this, the definition, we may easily imagine that assume that if the area is less than 400 nautical miles, there should be a competing territorial claims and the issues associated with uncertain maritime boundaries, which we witness almost every day. Article 123 of the UNCLOS is very much important when we discuss the duty to cooperate in this regard. This article say the state bordering an enclosed or semi-enclosed sea should cooperate with each other in the exercise of their rights and in the performance of their duties under this convention. So should cooperate come here from the article, specifically of the Article 123 of the convention. And we understand the very concept of duty to cooperate is a very important customary principle, in particular from the international environmental law. And the international cooperation is a very common and underlying theme of UNCLOS. However, nebulous nature of the term duty to cooperate demonstrate intentional ambiguity in treaty drafting due to the centrality of the state sovereignty. As we know that the interests of the community or interests of the individual states cannot go together all the time. So that differences came from that conflicts of the interest. So that difference also we have in terms of interpretation, so that the interpretation was different, so that the application was also different. There are many international cases also reported from the previous speakers. For example, Lanok arbitration, they mentioned that the consultation and negotiation must be genuine and must comply with the rules of the good faith, and there must not be mere formalities. It's the good faith repeatedly mentioned when you're dealing with the very concept of a duty to cooperate. And the other cases, for example, North Sea Continental Shelf case mentioned that the duty to cooperate, a duty to cooperate to require the parties, in this case, is a duty to negotiate, require the parties, so to conduct themselves that negotiation are meaningful. They continually, the many cases refer that the very important issues of the duty to cooperate try to formalize or materialize the very concept, what these terms means actual cases. For example, the Mox-Franco case, the obligation to cooperate is the overriding principle of international environmental law, in particular when the interests of the neighboring states are at stake. The duty to cooperate denotes an important shift in the general orientation of the international legal order. It balances the principle of sovereignty of state and thus ensure that community interests are taken into account vis-a-vis individualistic state interests. So again, the interests of the community and the interests of the individual states is competing each other, and which side should go to is quite a challenging topics in particular for the state parties when they face with the neighboring state within the very limited area. The South China Sea arbitration also emphasized that this case is very important indeed because from my own perspective, this laid down the very groundwork, emphasis the preservation and protection of the marine environment. One of the one part of this award say that the part 12 of the convention, which require the states to cooperate on a global and regional basis, directly or through the competent international organizations in formulating and elaborating international rules, standards, and recommended practice and procedures consistent with the convention. for the protection and preservation of the marine environment, taking account of the characteristic of the regional features. So the couple of cases which I mentioned here, and together with the manuscript presentation materials from the previous speaker, emphasize that international judicial bodies give us a very clear direction. The duty to cooperate is very much important, and very much emphasized for the member states to respect. And the element of duty to meaningful cooperation is very much important to be shared. And this is largely came from the whaling case in the Antarctic, and one of the parts of the written observation of the New Zealand. And in that, the written observation, New Zealand provided 4 elements. I think is very much interesting to share. The first element is a consultation procedures must be allowed to learn their course. And the second element is a meaningful cooperation also required that account be taken of the view of the others with a willingness to modify one approach. And element 3 is that due process must be observed in exercising right to provide in order to avoid encroaching on the rights of the contracting government. And the final, the element is that content of the duty of the meaningful cooperation is not fixed, but must instead take account of the gravity of the proposed actions for the interest of the other party. As I mentioned at the beginning of my talk is that I are quite interesting based on my personal experience dealing with actual cases. I emphasize that the states should not harm or jeopardize the current situation. But I never recorded myself is that I give some of the advice, the actual cases which I delivered that you have to cooperate with your neighboring state or the state parties in practice. So that, as I mentioned, that from the judicial body's interpretation of duty to cooperate or academic understanding of this terminology is one hand, and however how this understanding can be implemented in a step practice maybe the other hand. So that to fill the gap between the actual scene and step practice, and also the interpretation application of the convention by the judicial bodies and academics is quite a daunting task to be followed. Let me go to the details of the element which I mentioned to you. The first element, it go with the, for example, the pulp mill case. The case mentioned that in the view of the court, there would be no point to the cooperation mechanism if the party initiating the planned activity were to authorize or implement without waiting for the mechanism to be brought to a conclusion. Indeed, if that were the case, the negotiation between the parties would no longer have any purpose. So that element, the first element of the duty to meaningful cooperation, they emphasize that consultation procedures must be allowed to learn their course. And the second element, also emphasized by the cases I mentioned here. For example, no circumstantial cases, the courts say that negotiation would not be meaningful when either party insists upon its own position without contemplating any modification of it. And the Gapskov-Nazimos cases also courts say the obligation contained by definition, the general, and have to be transformed into specific obligation of performance through the process of consultations and negotiations. Their implementation does require a mutual willingness to discuss in good faith actual and potential environmental risk. So element 2, in terms of the duty of the meaningful cooperation, is that meaningful cooperation also require that account be taken of the view of others with their willingness to modify its own approach. And the next element, this 3, is that the due process must be observed in exercising rights provided in order to avoid encroaching on the rights of the other contracting the government. Yeah, I'm not familiar with the WTO cases, but one of the cases referred here is that United States, the shrimp cases, and that they say that it is only reasonable that rigorous compliance with the fundamental requirements of due process should be required in an application and administration of the measure, which purports to be an exception to the treaty obligation of the member, imposing the measure which effectively result in a suspension for this occasion of the treaty rights of the other members. So element 3 is emphasize the due process when we discuss the duty of meaningful cooperation. The last element is that the contents of the duty of meaningful cooperation is not fixed, but must instead take account of gravity of the proposed actions for the interests of the party. Here we have a very important the advisory opinion by the tribunal, which is respect to activities in the area. And the tribunal say that the greater the impact of state action on the interest, the greater the expectation of cooperation on the part of the state proposing to act. Such is particularly true where those interests lie in a shared resources. So together with the four elements which I mentioned, which derive from the whaling cases, I think it is helpful for the materialize the very concept of the duty to cooperate. And general duty to cooperate under the convention refer to many parts of the convention. In these days, it's quite easy to working on using the keyword. And you may find that the many articles refer to duty to cooperate. Due to the time constraints, I not repeat the articles here, but you may notice that some of the articles go with the shall, and some of the articles should go with should. So that the couple of the articles mentioned in the UNCLOS provide us that the UNCLOS has very emphasizing the very meaning of the duty to cooperate. However, when actual cases happen, how they interpret apply is another aspect of these articles. For example, if we look at the shall and the should cooperate, for example, in Article 123, which I mentioned to you, the very concept of the duty to cooperate of the semi-enclosed sea. That same articles, using that the shall and the should in a single provision, and so that unequivocal mandatory language used shall cooperate or the should cooperate give us some of the confusion when we have the actual the situation. And duty of publicity, notification, the exchange of the information. I believe that Judge Churk is the first presenter of today. The mention about these parts, and so that I'm not getting to the details of these parts. However, the duty of the publicity, notification of exchange of the information also very much confusing to the academics too. So that when we have actual cases to the tribunal or international judicial bodies, that enhance our understanding of these specific cases. And lastly, I want to mention about obligation enter into consultation of the negotiation. I think the current judicial bodies emphasize the duty to obligation to enter into negotiation among the broad framework of the duty to cooperate. So legal obligation require express provision in favor of prohibition of the conduct or results. And the legal obligation can arise from the implicit duty to cooperate. In particular, Article 118 of the Convention say that the state shall cooperate with each other in the conservation and management of living resources in the area of the high seas. And the state whose nationals exploit identical living resources or different living resources in the same area shall enter into negotiation with a view to taking the measure necessary for the conservation of the living resources concerned. So the various articles which I mentioned here although they provide us that the various format, but they try to formulate and they materialize the what is the meaning of the duty to cooperate in the convention. So that my conclusion is that I don't think that there is a different opinion in this regard. Duty to cooperate is a theme that resonates in convention. And the duty to cooperate is a very fundamental principle of the international environmental law, also international ocean law, applied to enclosed or semi-enclosed seas. And also duty to cooperate, it depends on precise contextual regime upon which the duty cooperate, in a sense that the enclosed, semi-enclosed seas, the duty should be more emphasized than other cases. And the reconciling statutory and the mandatory provision is important to achieve clarity. As I mentioned, that there is many suggestions to submit the recommendation to revise or the amend those issues, because to enhance the clarity is very much important. In particular, the duty to cooperate is one of the one of the agenda to set. And the negotiation to amend the UNCLOS to clarity obligation and the conceptual the legal basis here. So the practical measure and the regional approach to clarity standard for obligation that better encourage state conduct to comply across the various range of topics. And I don't think that is only one issue here. However, since the time's up, if I give my final talk, concluding remarks is that how this one they can be implemented in the state practice in general sense. We understand as I mentioned, again and again, academic interpretation or the interpretation and application made by the courts can go one direction very clearly to emphasize this is a very important aspect, in particular international preservation and protection of marine environments. However, when the actual cases, each state party dealing with their neighboring state, how they put the principle into their the policy when they're dealing with their neighboring states, I think that is the other one. So to fill the gap is very much needed. I'm looking forward to have your suggestions. So thank you very much. I'm going to stop here. Thank you.
Thank you very much, Professor Lee, for this very rich presentation on a specific but very important topic. Of course, it's quite obvious that for enclosed and semi-enclosed zones, the duty of cooperation is even more required and necessary and demanding also than in other situations. And I also retain from your presentation the fact that there is food for thought both at the conceptual level, that is on the articulation between the general system of enclosed and more specific legal system or regional systems, and also at the practical level. That is, at some point, the practice of the convention is very much at stake here, I believe, and probably we'll come back to that.